Hey everybody, welcome back to my channel. I'm your friend Arman. So today in this video I'm going to start with law of crime. So it's been really long day. I have made a video since my health was not good, so that's why I couldn't make videos. So but thank you so much, you guys has been loving my videos, and you guys have been like, I can see your comments that people are getting help out of my video. So I'm really happy that like people are liking my video, and yeah, I have noticing that the people are subscribing my channel also. So thank you so much who have subscribed to my channel and who has not subscribed yet. And if you're new here, do subscribe it, okay? And please share this video and ask your friend to subscribe to my channel also, because I'm a very new creator, and whenever I see a new subscriber, want to subscribe also, can bring a lot of happiness in my face. So please do that, and comment if you have any, like, if you like this video also. If you have any suggestions, queries, anything, you can comment down below. And please follow me on Instagram, and yeah, I have created a channel in Telegram also. If you want to get any kind of notes, then you can message there. So my Telegram link is also in the description box, so do find that. And so yeah, let's start today's topic. So today I'm going to start with the law of crimes. So yeah, so there are, in India we have generally 3 law of crimes, okay? So number 1, we have IPC, that is a substantive law. It's a substantive law, and we have CRPC, which is procedural law. It is a procedural law. And we have Evidence Act. This is also a procedural law, okay? So there are total 3 law of crimes we have in India. So it's a generally, okay? Apart from this also we have some other kinds of especially created criminal laws, like Dowry Prohibition Act, Domestic Violence Act. So those are also included, counted as a criminal law only, okay? So but however, that these 3 are the main branch of criminal law. So out of them, IPC is the substantive law. Substantive law here means the laws which gives the which talks about the punishment, or which defines the crime only, okay? And or say, like, you can also say that IPC is the, like, the substantive law are the duty imposing. It imposes a duty to the particular person, or as a whole in the society. But CRPC is like a procedural law, and the procedural law is what? So it gives the procedure to for the proper implementation of the substantive law. Suppose 302, which defines the murder, right? Defines the murder and gives the punishment. So how it should be done, what should be the procedure, which procedure the person should be convicted. So those kind of procedures are given under CRPC. So that's why the CRPC is the procedure. It's a procedural law. It gives the procedure for the enforcement of substantive law. All right, then comes the 3, okay? The 3 is the Evidence Act. So Evidence Act is what? That it provides, it is also a procedural law, and it gives the procedure how you can take the evidences from the evidences, like see, once the you file a FIR, generally in the IPC cases, then there will be a FIR. So after the FIR there will be a arrest, then there will be a trial, they will be produced before the magistrate, and there will be a trial, and there will be the procedure, okay, where there will be hearing. So during the hearing also the court will ask for the evidences. So what is the procedure for producing the evidences, and yeah, how the evidences should be collected from the the parties to the dispute. So everything will be covered under the Evidence Act, okay? So I hope it is clear to you what is substantive law and what is procedural law to you now. So here, so today I am going to give you the, like, general introduction of the IPC, okay? So we'll discuss about the IPC, okay? IPC, it is IPC is an Indian Penal Code. It is enacted in 1860, okay? It is enacted in 1860, and the chairperson of the person who drafted the IPC was Lord Macaulay, okay? So So IPC covers the crime. Okay, so it defines various kinds of offenses. Okay, so what is crime? We will understand this first. Okay, so since it is a introductory class, so I am going to give you the overview, like what is IPC and what are the things we will get in the IPC. So those things will be covered in this video today. All right, so so now the question arises. So we're going to see certain questions today. Okay, so what is crime? What is crime? So the first question is that what is crime? So crime is an act, either commission or the commission of an act or an omission of an act which is made punishable by a particular law that will be considered as a crime. Okay, so there is two things. Okay, as a human being, we live in the society, we do certain acts daily. So how we will decide that whether those act is a crime or not? Okay, so let's see. So there are so the act, so there will be act, always there will be act. The act will be commission, there will be a commission or omission. There will be either commission or omission. Okay, so commission is what? Commission is you have committed. Okay, you have committed which you are not supposed to do. Okay, which you are not supposed to do, or you are or which is forbidden by law that you should not be do. Suppose committed a theft. So you have committed the theft, and theft is prohibited by the law. If you should not commit the theft, so that is once you cause the steal something from the someone else, so that will be a theft. So theft is a commission, you have committed. Okay, and but when it's come to the omission, omission is the thing like which you are supposed to do but you did not. Okay, the law imposes a duty on you to do that but you did not. Okay, so that is an omission. Okay, so that is the difference. Okay, so in case of the commission there is a positive act. Okay, there is a positive act, and in case of the omission there is a negative act. Okay, so how it is, I'll tell you. So I'll give you the one example of omission. Suppose suppose a person, you have unlawfully detained him, and you did not feed him, you did not give the food to the person. Okay, you did not give the food to the person, and out of hunger the person died. Okay, so that is the omission, because you are supposed to give a food to that person but you did not, so that's why the person died. So that is an omission. You had not committed but it is omitted. Okay, so that is the omission. So the crime can happen in two ways, either commission or omission. Okay, so and crime is a very crime is not a certain thing like you will say ki this is crime and this is not crime. Okay, because crime is varies from place to place. Okay, a crime, a thing, a act which is considered as a crime in India, which will not be considered as a crime in other country. Okay, for example, 497 IPC defines adultery. 497 of IPC defines adultery, and adultery is a crime in India. Is a crime in India, but adultery is a civil wrong. Adultery is a civil wrong in England. So yeah, so this is the difference. So what may be a crime here, what may not be a crime in another country also. So the crime, so definition of crime is varies from place to place. Okay, so in general, if you have to say what is crime, then we will say an act punishable by law as forbidden by statute is known as crime, and the act which the crime damage. Okay, I'll write it down here for an act for punishable by law as forbidden by statute is known as crime. Okay, and the act which the crime changes person to person, nations to nation. Yeah. So yeah, so an act punishable by law as forbidden by statute is known as crime. As I have told you at the very beginning of the video, that crime is an act which is made punishable by a law, which is punishable, okay, which is punishable. An act which is punishable by the law, that is a crime. Okay, so it's the same thing here. It is then an act punishable by law as forbidden by statute is known as crime. Okay, so I hope it is clear to you now. And the crime, you know, varies from person to person and place to place. Okay, the reason being is that suppose a crime committed by, you know, committed by a child who is below 7 years, okay, you know, who is below 7 years is no crime. Okay, no matter whatever the crime is it be, if he has committed a crime and if the child is below 7 years, then he will not be responsible for it. So yeah, and if the same crime is committed by the person who is, you know, above, you know, 7 years, then he will be punishable, he will be punished. So yeah, so the crime, the, you know, varies from person to person and place to place. Okay, so that's what it is. So I hope it is clear to you now what is crime, and let's look at certain definition of crime. There is a very popular definition of the Bentham, that offenses whatever legislative has prohibited for good or bad reason. Okay, very simple. So Bentham is a jurist, okay, who is the propounder of the positivism, legal positivism, or yeah, analytical school. Yeah, according to the Bentham, so yeah, so according to the Bentham, offenses whatever legislative has prohibited for good or bad reasons. Okay, so any act which the legislature, so legislature is a parliament. If the whatever the, you know, legislature, whatever the acts which the offenses or acts which the parliament has, you know, prohibited for the good or bad reasons, so those acts will be, if anybody commits such acts, that will be a crime. So this is the definition of the Bentham. Okay, but in IPC we have not we do not found any definition. IPC do not defines the term crime. However, IPC defines the term offense. Okay, the offense is defined under section 40. Section 40 of IPC defines the term offense. Okay, and given under section 40 is very vague. Okay, it is not clear. It just says that so section 40 of the IPC defines the term offense. It do not define the term crime, but it defines the term offense. Okay, it says that except in the chapters and the sections mentioned in clause 2 and clause 3 of this section, that is section 40, under section 40 clause 2 and 3 of this section, and word offense denotes a thing punishable by this code. So what it tries to say is that whatever the offenses which is mentioned in the IPC, those will be, you know, considered as a crime or offense. Okay, that's what it means. All right, then yeah, another definition also given in the CRPC, that is section 2N. Okay, you should read out. Okay, section 2N also defines the term offense. Okay, it also defines the term offense, and it says 1971. Okay, so like section 2N of the CRPC also defines the term offense, which says any act or omission, as I have told you, made punishable by law for the time being in force. Okay, like it could be IPC or it could be any act which defines which, you know, which prohibits or which makes the act punishable. So those will be, you know, counted here. Okay, all of them will be counted here. Includes any act in respect of which the complaint may be made under section 20 of the Cattle Trespass Act. Okay, so you know, offense also includes a definition given under section 20 of the Cattle Trespass Act 1871 also. So any act created by the parliament which, you know, which makes certain acts punishable, those acts will be, you know, so those kind of acts will be you know, counted as a offense. Okay, so that's what it means. Okay, it does not only talks about the IPC, but it also talks about all the things, okay, any acts which will be which has already created or which will be created in future, and those acts which the parliament makes, which the legislature makes punishable by law, so those will be counted as a offense. All right, so this is what the crime means. Okay, so I hope it is clear to you what is crime and all that. Now we'll see the elements of crime. Okay, elements of crime. In the later video we will discuss in detail about it. Okay, so elements of crime. So there are elements, or you can say essential. Okay, essentials. Yeah. So the first essential is that there should be a human being. Number one, human being. There should be a human being, and number two, mens rea, actus reus, and injury. Okay, so these are the elements of crime. So number one, there should be human being, okay, who has either committed or who has suffered, and number two, there should be a mens rea. Mens rea means evil intention, evil motive, or wrongful intention, and actus reus means evil act. Okay, and injury, that means there should be a person who will suffer the injury. Okay, so these are the four essential elements of the elements of crime. Okay, so we will discuss it in the later part of the video. I'm just giving you the overview how the IPC will work. So yeah, so these are the four essential elements of the crime. There should be a human being, either who will commit or who will suffer or omit, and the second will be the mens rea, the evil motive, and the third will be the actus reus, which is also which means the evil act. Okay, evil motives, I mean, so whatever the act will be committed by the person will have to be coupled with the mens rea. That means if I have committed committed a crime, but I had no idea but I did it for the purpose, for the with a good intention, so that will not be counted as a mens rea. And if the mens rea is not present, the crime will not be committed. Okay, you cannot say that's a crime. Okay, because I had a good intention. So yeah, so bad intention, that means the mens rea is the bad intention, and actus reus is a bad act. Okay, so my mens rea should be manifested with the act. Okay, suppose I have committed the theft, I had created in my mind that I will commit the theft. Okay, so that is the mens rea, and the moment I committed, that means I have committed the actus reus, that means I will act. And the third is the injury, and because of that act, because of that theft, the person will suffer loss, so that is the injury. Okay, so these are the four elements of crime. We'll discuss in the next video about it in detail. So I'm just giving you the little overview of it. So since we have seen the essential, in the essentials, that mens rea is an essential element, but there are certain crimes where the mens rea is not essential. Okay, so mens rea means criminal intention. Okay, so in the case of there are certain cases. In the case of bigamy, section 494. In case of the four crimes like bigamy, public nuisance, contempt of court, and the abduction and kidnap. So in the cases of these four, the mens rea is not essential. Okay, the evil motive or criminal intention is not required. Okay, bigamy is what? Bigamy is marrying another wife. When you are already married, and if you marry someone else, that will be bigamy. Okay, so that is also a crime, and you cannot say that I had a good intention, that I wanted to help that lady, so that's why I married another woman. So you cannot say that. Okay, so bigamy is a crime under section 494. And public nuisance is, we have discussed in the law of tort class also, that public nuisance is a crime. Okay, it is a crime committed against the whole society at large. And number 3, contempt of court, when we contempt the decision of the court, or we do certain things which will defame the court, so that will be contempt of court. And number 4, we have the abduction and kidnap. Abduction, when the abduction is major if you kidnap person who is major, that will be called abduction, and if you do the minor, that means the abduction means पलायन करना, ठीक है, लेके भाग जाना, किसी को लेके भाग जाना, so that will be abduction, and kidnap is in case of the minor only. Okay, so yeah, so this is also, so this in cases of the these four, the mens rea is not essential. Okay, now we will see the where the injury is not essential. Okay, is not essential. So here injury is not essential. Okay, so so number criminal conspiracy. So yeah, in these three cases, injury is not essential, though the person has not suffered any wrong, but even if you try attempt or abetment or criminal conspiracy, the person will be responsible, person will be given punished, person will be punished. Okay, so what is attempt? So suppose I am giving you the example of attempt, that is attempt to commit suicide, attempt to commit rape. So everything will be, if you try to commit attempt, and the act is not successful yet, but still attempt will be, since you have tried to attempt, so you will be punished. Okay, so this is attempt. And the abetment means the fomenting. So the synonym word is abetment is the fomenting, that means bhadkana. Okay, किसी को भड़काना. Okay, so that is abetment. So if you try to abet, or if you abet somebody to commit a crime, or if you abet somebody to commit a suicide, dowry death, or anything, so that will be abetment. Okay, so suppose I'll give you the example. There is a A and B who is fighting. They are fighting together. There is a fight between them, and what C did. Okay, C incites A, or say foments A, or say abets A, that if I would have been in your place, I would have already killed B. Okay, so with that, you are so coward, you could not kill him. I told him, you are so coward, you could not kill him. So and out of in order to prove his masculinity, what he did, he literally killed him, or caused the injury. So here I have committed the abetment. Okay, I instigated him, sorry, not instigation, that is a fomenting, or I abetted him, then he accordingly he committed the crime. So that is the abetment. So here in this case I will be punished, okay, for the abetment, though I have not done anything, but since I have abetted the culprit, so I will be responsible, I will be punished. And the number 3 is criminal conspiracy. Criminal conspiracy means to do certain act which is conspiratory, that means षड्यंत्र करना, ठीक है, suppose चाल करना, ठीक है, like I have decided that A, B and C, the 3 people, they have mutually agreed that they will commit a theft in the B and D's house. Okay, D's house, they have decided, they have conspired that I will suppose I will abduct D, and A said, I will abduct D, and B and C, you will go and commit the theft in his house, and once he will come back, I will release him. Okay, so that is a conspiracy, that they have created a conspiracy. Okay, so this conspiracy, though they have not committed yet, but still the conspiracy, if it is leaked, if people get to know about it, then the person will be held responsible for it. Okay, so yeah, this is the injuries. This is these 3 things where commission or injury is not required. Okay, and now we'll see the crimes where neither act nor injury is required. Neither act nor injury is required are: number 1, making preparation for committing dacoity. So yes, the crimes where neither the act nor the injury is required. Okay, they have not committed nor the injury nor the person suffered any injury, but still those kind of actions will be termed as crime, and those acts are made punishable under IPC. Okay, and because those acts are considered as a considered in a very serious crime. Okay, so there are total 4 crimes which is punishable, okay, without even committing or causing injury. Okay, number 1, making preparation for committing dacoity. Okay, if you prepare to commit dacoity, so that will be punishable under section 399. Okay, so we will discuss in the later in the next videos, in upcoming videos, what is dacoity in detail, so I'm not going to do that. And punishment for belonging to the gang of the dacoits, that is 400. And number 3, that is also talks about the punishment for belonging to the gang of thieves, that is section 401. And again assembling for the purpose of committing dacoity, that is 402. So in 4 cases it is not necessary that there should be a commission of the act or the injury should be sustained. Okay, so there is also a concept of vicarious liability. Vicarious liability under tort, sorry, not tort, under IPC. There is a concept of vicarious liability in IPC also. It's so generally the vicarious liability means a liability for the commission of the act of the another person. Okay, or say the act of the servant binds the principal also. Okay, so under IPC there are certain sections which provides the section for vicarious liability. Okay, so the concept of vicarious liability we find in IPC in the following sections. Okay, following sections are sections are like section 154. Okay, owner or occupier of the land in which the unlawful assembly is held. Okay, so I will not write it down. You just write it down in your copy. It will be a notebook, and you can see it in after this video. Okay, so section 154 it talks about the owner or occupier of the land on which the unlawful assembly is held. Okay, section 154. And number 2, section 155, liability of person for whose benefit riot is committed. And section 156. Okay, so these 3 sections, in 3 sections the vicarious liability comes. Okay, so if there is any unlawful assembly in the suppose I have this land and I have given it for tenancy. Okay, it is under the tenancy agreement, and and so being a landlord, I have given this land for the tenant, to my tenant, and there is an unlawful assembly conducted, so I will also be criminally liable. Okay, so these 3 things talks about this kind of acts only. Okay, the vicarious liability. So how the owner will be vicariously liable, so section 154, 55 and 56 deals with it. Okay, so this is the concept of vicarious liability in IPC we find. So protection to the accused, we will see discuss about it in the next video. Protection to the accused, we will daily we will see one topic in IPC, one chapter we will cover in IPC every day. Okay, so protection to the accused, constitution also provides under article 20. Article 20 is only for like the accused person. Okay, so article 20 provides, it's a fundamental right. It provides the like right to be informed, and double jeopardy, many things are there in the constitution, so you can go through that. Okay, and in IPC section 300 also talks about it. Okay, what are the rights that the accused person has. Okay, like right to legal aid, presumption, many things. Now we will see the punishments. So we will see the death sentences. Okay, DES, death sentences. So we will see the cases in which the death sentence is given. Okay, under what are the sections which gives the death sentence. Please write it down because it is very important for the exam point of view also. This may be asked for the this might come for the MCQ questions also. So I will write down to section 121, waging war against the government. Okay, waging or attempting to wage war abetting government of India, and section 132 and 132. Section 132 is talk abatement of mutiny in committed in consequence thereof. Okay, so section 122 deals with the mutiny, abatement of mutiny, and section 194 Section 194, giving or fabricating false evidence if innocent person be thereby convicted and executed. Okay, if you fabricate any evidence and because on the basis of that if any innocent person is executed or convicted, then you will also be given that sentence. Okay, then comes section 302, punishment for murder. 302, punishment for murder, that is also death punishment. And 305, which deals with the punishment for the murder by life convict. Okay, then comes 307, it attempt to murder by life convict. And 364A, kidnapping for ransom. Okay, and comes 396, dacoity with murder. And 376A, punishment for causing death or resulting persistent vegetative state of victim. 376A. Then comes 376E, that is punishment for repeat offender. Okay, so in in these cases, okay, under this section death sentence is granted. Okay, there is a probability of given the death sentence. Okay, section 121, 132, 194, 302, 305, 307, 364, 364A, 396, 376A and 376E. Okay, so in these cases the death sentence will be given. Okay, like the court may grant death sentence. Death sentence is given in very rare and the rarest cases, and there are very cases in the Supreme Court also whether the death sentence will be violative of the Article 21 or not. So yeah, I have asked that question in my previous video, but nobody answered it. So the imprisonment. So we'll see the imprisonment in like maximum imprisonment. Maximum imprisonment is given for 14 years. Is 14 years. 14 years under section 392. In case of the section 392, maximum imprisonment is given for 14 years under section 392, and minimum punishment is 24 hours. 24 hours under section 510. Section 500. Under section 510, minimum punishment is given, imprisonment is given for 24 hours. Okay, the maximum is 14 years, section 392, and minimum is 24 hours, section 510. Okay, so yeah, so now we will see the steps of crime. Okay, steps of crime. We have seen elements of crime. Now we will see the steps of crime. Okay, the number one step is that number one, intention offense. Okay, these are the steps of the crime. Like first of all, the person will think in his mind that okay, I will commit this, and preparation for that the person will do that, make the arrangements, and third, attempts, and if the attempt is accomplished, that will be offense. Okay, so this is the steps of offense, and we will discuss it in the next video in detail. So today, since it is introductory class, I am just giving introduction about it, and now we will see offenses. So these are the what are the offenses where the only intention is punishable? There is no, suppose if you only have the intention, you will be punished. Okay, so the offenses are abatement and criminal conspiracy. Okay, as we have seen, abatement and criminal conspiracy. Okay, so these are the steps, and those are the offenses where the intention will be punished. Okay, abatement and criminal conspiracy. Okay, now we will see the number of persons required for the commission of the particular offense. Okay, so section 34, it deals with common intention. This is very important topic. We will discuss in the next video, common intention. So common intention, for the commission of the common intention, the minimum offender is required 2. Okay, person required 2. Okay, 5. Okay, so this is the list. This is important. Write it down. Okay, it will be very helpful for you your viva or anything. So the number of persons required for the particular crime. Okay, so for the section 34 common intention, 2 persons is required, and section 120b criminal conspiracy, again 2, and section 149 common objects, 5 persons required, and section 117 abatement 10%, and 391 dacoity 5. Okay, so these are the number of persons required. If there is less than 5%, there will be different crime. We will see in the later part of the next video. Okay, so main important topic here is like common intention, common object, criminal conspiracy. So these are the very important topic of IPC. We will discuss about it in detail in the next videos. Okay, so and there are certain theories of punishment also. We will look into it also. Punishment. So it means what's like on the which theory the punishments are given. Okay, so there are total 5 theories, that is a retributive theory. So yeah, so there are total 5 theories: retributive theory, deterrent theory, expiatory theory, preventive theory, and reformative theory. So on the basis of the 5 theories, the punishments are created. Okay, like for this crime this amount of punishment will be given, and for that crime this amount of punishment given. So all of the punishments are based on this, based among these 3, and out of this theories of punishment. Okay, we will look in it in the later part of the next video. Upcoming videos we will discuss in detail everything whatever we have discussed so far. Okay, so this is all about the introductory class of IPC. I hope you like this video, and if you find this video helpful, please do let me know by commenting down below. And yeah, thank you so much for once again for watching this video. So from tomorrow we will see in detail IPC. Okay, we'll see every sections and every crimes we will discuss in detail from tomorrow. Okay, so I'll see you in the next class. Bye bye.